Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search, because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to marijuana.
and that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case 5,001, and then the new case, of course,
I'll
would be
leave the
bonded out
first
as.
one or the second one as is, though. So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
That's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas
Yeah,
driver?
yeah, eligible.
I'm now revoking your bond on the other two cases. You will go into custody with me because you picked up a third case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to
I
address that.
wanted to have
I'm not going to talk to you about this case. You have a lawyer.
I
You need
wanted
to talk to the
I wanted to
lawyer.
talk about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give.
Because you wanted the bond conditions.
Good morning, Mr. Barnes.
Good morning. Sir Davis, sir.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave. Don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them still open. Paul Two's representing him. I talked to Paul yesterday. And it's set for sometime in March. I can't recall the exact
It's
date.
okay. Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex,
Yes,
please.
Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Tell me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down. That
All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right? Really. You hang with dogs, what happens? No. You get fleet. Well, you can get bit too, right? Please.
It's a bad dog.
Just don't hang. So understand that your lawyer is here because he wants me to set you a bond. I don't know. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, what matters to me are two things. Number one, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this case here, this is a new case.
Yes, Judge. It was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor,
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22,
Yes,
23?
Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secured.
This is that, you know, it's just such a short time. He's picked up this case. He's picked up, I guess, a weed case, you know, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond for did they file a motion to adjudicate on the
Aggravated
rob?
robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently,
No,
yes,
no.
Judge.
And it was dismissed because the Brennan marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun and I don't know if there's shooting involved, but you know, the good news is though, is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So you said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, you know, in was it Lafayette?
Is East Baton Rouge,
East
and
Baton Rouge.
currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so obviously I can't speak for the trial bureau, but if they decide to revoke.
Huggin, you got to understand when you're on felony probation, something like that, you got to live with a halo on your head because you could be looking at 20 years, man. All right.
Thank
Thanks.
you, Your Honor.
Thank you, Judge.
Yes, sir.
This is one of the harshest labels a judge can use at this stage: dangerous. It signals real concern for public safety and explains why bond is denied despite defense arguments. Prior cases, probation status, and repeated violations stack up fast. Do you think the court made the right call here, or should strict conditions have been enough?
You were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond, put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any prior DWIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those two documents. I will have you sign a receipt with Victoria. We will have you get with Fleischer at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. And then if you could give her an application. Mr. Leary, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, at approximately 12:51 a.m., the officer unviewed two vehicles at the block of Tomball Parkway, blocking the moving lane of traffic. The officer observed a white Jeep and an orange Corvette line up directly next to each other side by side, and the vehicles accelerated at the same time at a high rate of speed. The traffic stop was initiated of the white Jeep, and the officer made contact with the defendant, the driver, who gave his name and was identified by his Texas driver's license. The other officer stopped the Corvette and detained the second defendant. The driver was positively ID'd by the Texas driver's license.
You know how fast they were going?
Your Honor, they do not specify in the DIMS.
Okay. Mr. Leary, I'm going to find that there's probable cause to go forward with your case. Have you run his license, see if he has it?
Eligible, Your Honor.
Okay. I'm ordering you as a condition of your bond not to participate in this kind of behavior again. If I see that you do, the first thing I'm going to do is I'm going to revoke your bond, put you in jail. The next thing I'm doing, I will take your privilege to drive away from you permanently. Do you understand while this case is over?
Yes, sir.
Open. The ability to not drive in Houston blows. Trust me. Do you understand?
Yes, sir.
Now, you have a lawyer. It's your responsibility to stay in touch with Mr. Clay, and he'll tell you when you have to come back to court. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court.
Yes,
You
sir.
pick up a new case, you endanger my public. I only have one place for you. You understand?
Yes, sir.
All right. So I'm going to have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Yes, sir. Thanks. It's come to my attention that you've picked up a couple new cases while you're on bond. So state's asking me, or I guess, what are you asking for, state?
We were asking for 5,000 on each of the cases.
To revoke the bonds?
Yes, sir.
On which cases?
On one moment,
Mischief.
the criminal mischief and the assault bodily injury.
And that is because he has picked up a new criminal trespass.
Yes, sir.
Did you say that there was one that you were going to have indicted too?
Yes, sir. And we're pending on the offense report for that still at this time. So we're waiting for a new date.
What is that?
What is that case?
Yeah, what is that? Is it another trespass? Is it a theft?
Assault bodily injury.
Oh, there's another assault.
Yes, sir.
Did you know about this?
Yes, because that one was no PC by the magistrate when all of these cases came to the court. But it was no PC because they, I think, fat fingered the date of the offense as 2021, not 2024. And so it was outside the statute of limitations when it went before the
Someone
magistrate.
accidentally put 2021 on the actual report instead of
And
24.
yes, my understanding is that the state is having to get a copy of the offense report, and then they can take it to the grand jury with the correct date.
Okay. So what is your response as far as the mischief and the assault on the bond revocation?
We're in agreement with the 5,000.
Okay.
He has a case upstairs, so.
Oh, I see. Right. You have a felony case. So, all right. So on the mischief and then the assault, if we can put it at now 1, 2.
Judge Jackson had previously revoked the ABI when they were last week.
Yeah, but I think they're all in agreement. So we'll do 5,000 and 2, 4.
5,001. Yes.
Yeah, on the assault and the mischief. Right. We'll leave the trespass as is. Right. So Mr. Rodriguez, what's happening now is I'm going to revoke the bond on your 2 older cases due to the fact that you continue to pick up other new cases. You can't expect.
Right. Yes,
Right. So,
Just for clarification, the case that's being taken to the grand jury, that's already kind of accounted for in the 5,000. There's not going to be a new BVR when that.
right.
Okay,
What do you,
I'll defer to you on that, Your Honor.
okay.
okay.
I'm okay with that.
Okay.
Right. I'm not going to just be duplicitous to kind of just, that we're looking again.
Okay, I just want to make sure we're all on the same
So
page.
what do we set it at when we actually do get it?
The ABI,
Yeah, the new one.
um, to be completely candid, Judge, I don't know that it really matters because 1,000 or 11 billion, thousand, it's.
Yeah, I guess we'll cross that bridge when we get there, whenever they do get it done.
Yeah.
Yeah, okay. All right, so if you do bond out, I'm going to put a GPS monitor. I don't know if you're going to get out or not, but I'm ordering you not to have any contact with the complaining witnesses in these cases, not to be in possession of weapons, and I'm going to put a monitor on you so I know that you're not going over there. The monitor will go on you prior to your release from custody if you are able to make bond. Do you understand? Do you have any questions? Okay, man. Good luck, Mr. Rodriguez. So we need him to sign before he goes, please.
Thank you.
Thanks, guys.
Be excused.
Yes.
Just come over here, Mr. Rodriguez. Have you signed for your bond?
So I will, Kelsey, I'm going to grant the motion that you did in the queue, the motions that you filed, I'll grant them.
Thank you, sir.
Okay. Are you ready? Okay.
Judge?
Yes, ma'am. I already done it.
We're good?
So what I'm gonna do, just unset term. Yeah, he's a big boy. He knows. We're done. Doesn't want the help. We'll just unset term and then he's just free to go. So just, nope, just admonish him if he picks up another case. Thank you. Yes, ma'am. Mr. Butler. Yes, I'm ready.
Really Hassan that's on the dock.
You've been so patient.
What's that?
You've been so patient.
I get, well, I had some rounds to make this morning.
Hassan.
Yes, Hassan. So she's here from California. So what happens is she's on PTI. We get notification that there was some sort of violation, we hadn't pulled any of the stuff to really take a look at it. She's given me,
You've not seen what the violations are?
I'm sorry?
You've not seen the violations?
No. I've seen like the kind of the blanket thing where they allege the usual, like a blow, something like that, or a missed blow.
Ms. Hassan, come up.
And so what we're gonna request is obviously a recess to be able to speak to the appropriate person. Ms. Geis, I believe, is in charge. Right.
Has she already been booted out?
No, this is the initial, they always,
If everything didn't happen on the PTR program, she would. Because I guess everything is in limbo. They're just waiting.
What violations do we have?
218 is a lot. She's averaging 14 to 34 skip tests a month on her device. She tested positive for THC. She failed to report for her office visits on the September 24th, October 8th, December 3rd, December 31st, and January 8th.
Can I,
No,
so obviously.
actions speak.
yeah,
Right.
but Your
Stop,
Honor.
stop. Don't. Got a lawyer.
I'm so passionate about this. If I could, Judge, we would just request a reset. Let me get all the.
So, but I'm now going to put an ankle monitor on her so I know that she's not consuming. I'll pay for it.
Did you fly here?
I did fly.
Did she
So-
fly on an airplane with that?
I would assume so. But she's on bond in this court. She's skipping tests that she's not supposed to be doing. I'm putting a scram monitor on you. That's it.
I do have an answer.
Guys, you talk
Yeah.
over there. You're on bond in this court.
Okay. And I will travel as well with the monitor, but I did have an issue last time I came with the DUI machine. It stopped working because I traveled out of state and I was ordered to pay a whole new device, turn it in, and I had to wait a whole week without testing because of that problem. So I just don't want to run into that same problem with the ankle monitor.
So when you have issues,
Mhm.
you're supposed to contact the provider immediately and let them know, hey, I've got an issue. You go to where they are, right? And there are devices that they're global. You can go all over the globe. They use, Wi-Fi or whatnot, so that it doesn't matter where you are. You can be in Abu Dhabi. You're still able to use the device and the device can go internationally. There's just, if you know that that's a lifestyle you have, that's the kind of machine that you get. So regardless, so, I mean, I'll give you, the case is 400 days. I will give you some time, right? Tell me, how much time do you want?
I don't know, like 3 or so weeks, or, you know,
Done.
because everything else in the way, but, and then can we wait for appearance the next setting?
Well, I don't know yet, because if they deny it, then we need to figure out what we're gonna do.
Figure something out. Yeah.
So,
Like she and I haven't really had the time to sit down and just really go through, you know, like obviously she's very passionate about what happened and.
so amending your bond conditions, you will get a scram ankle monitor now. If I find that you're consuming alcohol, and I don't care what it is, I don't care if it's mouthwash, I don't care if it's a tequila lollipop, I'm gonna revoke your bond. Do you understand?
Yeah.
Can you run her license to see if she has a license?
Yes, Judge, I'll run it right now.
Today,
At what time?
later in the evening, like around 6, 7.
So Judge, her flight leaves today at 6 p.m.
She's gonna go now. We'll get her in now.
Get it done
Right now.
Okay, right.
Your Honor, it appears to be a valid California license.
As long as you have a valid license and liability insurance, then you can drive unless, well, no, you're not allowed to drive without an interlock. So you have to have the interlock.
I'm not driving right now.
I'm just telling you what
Okay.
the expectation is so that, you know, I don't want to have to revoke your bond. You have to know what the expectations are. Now, okay, so we'll give you whatever time you want at the next setting. Because your case is old and because of their violations, I'm not waiving your appearance anymore. If you get her back in to the program, I guess at that point, we don't leave her here, right? I'll waive it. But if it's denied, then she's got to come back here so we can resolve it one way or the other.
Okay, I'll just find a date for it.
Just let me know. Yeah. Okay. All right, man. Good luck. Fair, you are charged with assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used.
And here's the moment defendants underestimate every time. Bond conditions are promises, not suggestions. The judge isn't punishing new behavior yet. He's responding to broken trust. Once that trust is gone, the court's patience disappears fast. Would you have expected bond revocation this quickly?
Against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister,
Okay.
Your Honor.
We know of alcohol or any kind of,
There's no allegations, Your Honor.
see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay. If I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? You need a lawyer, ma'am. Okay. Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay. Please, we'll have you sign a reset. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residence of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get
restrictions, like a.
Sure, just provide it
That-
to Felicia so she knows, and then we'll put that in the order as well, that she's not to go to this location.
Yeah, Judge.
Okay, okay, ma'am, please. Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m. And the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plates through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car?
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir,
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll help you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
And
Mr. Shagoya, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, at approximately 4:30 a.m., the officer observed the vehicle fail to stop at a red light at the East Texas Freeway on Harris County, Texas. The vehicle would have struck the officer's patrol vehicle had the officer not come to a stop. A traffic stop was then initiated, and the vehicle continued to drive 0.5 miles before stopping. The officer made contact with the defendant, the driver and sole occupant, and observed an odor of alcoholic beverage, glossy eyes, and slurred speech. Standard field sobriety tests were conducted, HGN 6 out of 6. The officer did not conduct walk and turn and one-leg stand due to safety concerns and the nearby sidewalk not being level. The officer observed a Glock 9mm in plain view from the front passenger window located on the passenger floorboard near the center console, and a PC search was then conducted. A second loaded firearm was found in the center console, and the defendant was then read the DIC and refused. A blood search warrant was signed and executed.
Mr. Shagoya, I'm going to find that there's probable cause to go forward with your case. Have you run his license?
It is eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to be in possession of any weapons as well, sir. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you, or you've taken off and you pick up a new case, I will revoke your bond. Have you looked to see if he has any prior DWIs, Alex? Please.
He has one moment, Your Honor. No priors.
Okay. All right. So for now, I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions. And after that, you'll be free to go, sir.
thank you, Judge.
Thanks, guys.
Excuse me.
Please. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant has been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining
Same
witness?
complainant.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yep, Judge, the MOC was signed last Friday. It was signed by a magistrate court. On the 18th, or last Saturday, actually. You scroll all the way to the bottom.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was,
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay, come on. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 13th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed without a front license plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door, and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community, it's not going to go well for you. Do you understand? And we'll have you sign a resolutoria. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
Thank you for this.
You were charged with tampering with the government record with intent to make it genuine? Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with the government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck, that he receives a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says he was saying.
Well, that, right, but I mean.
Right.
Marcos, I see what you're saying because he's charged with tampering, right? To tamper, you must. I know, let's pull the code.
Right.
Because I mean, do you have to make a willing?
But you negligently or recklessly.
An alteration, so to speak, you know? Let's see. $37.10. Bless you. No, that's. Oh.
Knowingly makes a false entry in the false alteration of a government record.
A person commits, if he knowingly makes a false entry in or false alteration of a government record, makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor.
I think that is what they're probably relying on in this case.
If I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So.
Well, he doesn't know it was obtained unlawfully, even from.
Well, hold on. That's your burden, right?
Yes, Judge. And in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, you know, from the state authority, right? They give you the license plate, but here.
They give you the paper plate and you assume that they're going to do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
If this had been like maybe a month or two that he purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long.
and it's this car purchase.
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists a date of loss as June or May 29th, 2020. So I don't know if that's when the defendant obtained it, or that's just.
No,
when it
that's
was
just
salvaged.
when it was salvaged at
Yeah,
that
so
time.
that's
So
the
at that
only-
point, you can't even drive the car because it's salvaged, right?
Right,
It's
and
a
that's
salvage title,
the
but
date that the officer provides. So, and, so with the information we
you have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025, and lists the vehicle as a 2007 Chevrolet, and it doesn't
Is
list.
this, it should say like a date of purchase, right? Why don't we do this? Look,
So it says it expired February 5th, and this happened on January 16th, and I just asked him when he bought it, he said it was about a month and a half ago. And I said, how many
so let's do this. Show me, let me give you more time. Let me just do a little bit more diligence, all
Okay.
right? We'll come back, but let me burn through all this because I didn't think it was going to take this much time, but we'll revisit. Okay.
Yes, don't listen.
So, Mr. Montalongo, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already.
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay.
Okay, go for it.
Yes, Judge. On February 28th, 2023, the officer responded to a terroristic threat, and the complainant stated she is the sister of the defendant, and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, "I hope you take a punch to the fucking face. I'm gonna break your fucking face with my fist, bitch. I want to hear your bones break." The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to
Because I'm
happen, or
going
some
to.
future event.
I mean, I'm going to.
I'm going to, can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like,
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent, therefore it's not, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, "I'm gonna break your face with my fist." So that would go towards, I doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, the I'm going to, and just the overall tone of the
Mhm.
message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must back at that time to figure out what we're going to do. You must either accept a plea bargain from the state or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. We'll go from there.
Understood, Jeff.
Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is.
So are they next door neighbors?
No, they live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Really, that's all we're asking to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have the right to have an attorney present. If you're not afford one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended their relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works. No weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with Fleischer for your bond conditions. I'll provide your lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 20,
hold on.
Yes, Judge. Okay. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back two metal sheets that lead to two large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how the how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a
I
look
mean,
at
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of course, Judge.
So,
Thank you.
But until that time, don't pick up a new case. Don't go back. All right. So Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond condition. We'll have you sign it, and then you'll be free to go. Okay?
Thank you.
This is where things quietly turn serious. Scales, baggies, and hidden packages don't just suggest possession, they hint at intent. And even though this is only a probable cause hearing, that low legal threshold gives judges wide discretion. Question for you. At what point does a traffic stop being routine and start becoming a full-blown criminal case?
Well, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Ms. Newton, you now stand charged with two more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An APHIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of this year, of last year, and now two more cases. Was she on bond for either of these cases when she picked up the two new cases?
Let me see, Your Honor.
Okay. You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254, 8009.
Your Honor, it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got put in. So it's a third name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243,
Yes, Judge, on the 243.
that's the one that was
the
in
GOP.
current status, right?
Yes, Judge.
Where are all those from?
So the theft cause number 243 was a Dick's Sporting Good.
So Dick's,
and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Ms. Newton, Ms. Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a fifth case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? Okay. We're going to have you sign a reset with Victoria. After that, you'll get with Fleischer for your bond conditions. Do not pick up a fifth case. I'm telling you now. I don't know what you're doing, but you pick up another case. You're also not to hang out with the other person, the co-defendant in this case as well. Do you understand? So can you reach out to the MAC for her, and then she'll have conditions with Fleischer? Okay, please, ma'am. Morning, Mr. Price. So you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Ms. Judge, the complainant Terrell and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walking to the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a?
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. You see one?
I don't see one final.
Okay, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You will need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. You look up to see if he has a...
It's not eligible, Your Honor.
We're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Let's see if I have it. Show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of 2 lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted, and the officer made contact with the defendant, the driver of the vehicle. The officer observed disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard filter Bradicus were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were 0.290 and 0.294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold? Or
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, man? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, man. No more PR bonds. Have you run your license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, ma'am?
Yes.
I'm going to do everything in my power to protect my public at all cost. Every single day, someone dies from a DWI in our county. I need you to fill out an application for me, and, or you know what, hold on a second, maybe not. Vic, I have an application on file already, so if you just want to appoint her a lawyer, I'm going to have you sign a receipt with Victoria. You will meet with Fleischer for your bond conditions, and after that, we'll have you take your seat while I find your lawyer. I'm going to have you sign a reset. After that, you'll get with Fleischer for your bond conditions. After that, I'll have you take a seat while I find your lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit, right.
I spoke with her again. She said that she needed to reach out to her dad and brother to see a time that would work for him to come.
Where is the car?
The
Where?
car is at the property at,
Is it in the, like, you know, apartment complexes have outlying lots. They have lots that are inside of a gate. You need a code to get in to get the car. She didn't say where the car is?
I know the address of where the car is. I don't know exactly what type of property it is.
Can we do an in run around the stretch? If you'll allow exemption for me to do all the middle manning, my client just don't pick up the vehicle. I'll get it. I'll talk to them and
Okay.
get it somewhere.
And you're an officer of the court. I trust you. You know, find out where the car is exactly so he knows exactly where to go get it. hopefully it's not in a complicated place where he's gonna have to talk to them because I don't want him to talk to
Of
them.
course, I
You
will
know?
be communicating with them about anything from him, for him to
Yeah.
get the.
So let them know that he's not to talk to them. If he goes and tries to talk to them, I'm putting him in jail, right?
Yes, Judge.
Just to get the car, that's it, and
I
get the middleman, right? Yeah, of course you can. I mean, you're the go-between.
Yes, Judge.
Okay.
Okay,
Thank you, Your Honor.
for sure.
Will we need to redraft that? Or just finish on it?
Let me see what it says. Hold on.
But technically, if I'm doing it, I guess it's still no contact.
So what I'm gonna do is I'm going to edit this to say this. It says, do we know what day he wants to go back?
I don't know, Judge, I'll have to sort all that. That's why I'm saying there's gonna be some contact about, is there a gate code? Where is it? When? So I need to,
Because he's got 3 days from the date of that letter, right? When was that letter?
I think it says until the 25th.
Okay, just remind me.
Okay, so I'm gonna put here, defendant has until 1:25 to go get his car from the above listed address. Defendant is not to have any contact with the complaining witnesses and no weapons as well. So he's going to be the middleman to figure out where that car is for you to get it. You get it and you go. Don't dilly-dally. Don't try to talk to them. If someone comes, just get it and go. Make sure you have everything with you. They're probably going to maybe want insurance. Don't bring an insurance card. You know, it's like when you go pick up your card at your car at like an impound lot. You need your insurance card. If you don't have insurance, they're not going to give it to you. Make sure you come with the keys. You got your insurance card, everything, so that you know. You understand?
Yes, sir.
Okay. All right. We'll have you sign this. So you know what you can and can't do.
Yes, sir.
All right. Okay, good. Come up, sign it. We'll let you go.
Thank you.
Okay. And thank you,
Thank you for your patience.
JP. No. Thank you. You're doing great. Sorry, Mr. Pons. I'm just,
The affidavit and that she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that.
you. That's why I'm up here. Challenging the PC on that one? There's an affidavit, a complaint that's provided.
There's an affidavit. Because in the
Hey,
DIMS,
this is on Corral? This is a new case, right?
It's a complaint, so it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him
I
as
thought-
well.
But you said that you did feel pain.
the complete DIM.
I wouldn't, or that's the problem is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about. That the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on your body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress of the excitement, so you're not feeling it. But then after
That's not what she said though, or that's not what
Stress.
was going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
not in that.
asked- But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
the officer
ask?
never asked. He came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying
No.
taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that connection.
You don't operate on hunches.
Right, and she's also stated that I was fighting him, so that could be because of her
I mean,
fighting.
here's the deal. Like if I find no PC, right, they may just re-indict it though.
That's fine.
No.
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on bottom on camera, he never says, we don't know.
But well, I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there were visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know?
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if you
mean-
lay it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element. So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find no PC.